Hi, Maureen. Hi, everyone. My name is Hannah from Forum, and I'm glad to be here.
Thank you, Hannah. We now go to John Imoite. John, kindly unmute and say hi to everyone.
Hello, everyone. My name is John Imoite, National Chairman, Kenya National Congress.
Thank you so much, John. We now go to Bwana Ruho, Joel Ruho. Ruho, if you can hear me, kindly unmute and say hello.
Hello. Thank you very much. I'm Joel Ruhu, the National Chairman of Ford Kenya Party.
Thank you, Bwana Ruhu, and welcome on board. We go to Justus Anzanya. Justus, kindly unmute and say hi to everyone.
Hello, everyone. I'm Justus Anzanya from the Labour Party of Kenya. I'm happy to see you.
Thank you. Thank you so much, Justus. We now go to Lilian Anyango. Lilian, kindly unmute and say hi to everyone. Lilian, if you can hear me.
Hello, Maureen. How are you? Can you hear me?
Yes, I can hear you now.
Thank you. Good morning. This is Lilian Anyango, Women League Leader, Kenya National Congress. I'm happy to be here.
Thank you so much, Lilian, and welcome on board. We now go to Ms. Sela Opio. Sela, kindly unmute and say hi.
Hi, everyone.
Hi. Thank you, Sela. We now go to Mr. Stephen Namusule. Bwana Idi, kindly unmute and say hi to everyone. Bwana Namusule, if you can hear me.
Hello, Maureen.
Hello, good morning.
Can you hear me?
Yes, we can hear you now.
Oh, thank you. Happy to be in for this meeting. Yeah, my name is Stephen Amshule, the Executive Director for Kenya.
Thank you so much, Bwana Idi, and welcome also on board. We also have our ED, Mr. Tabu Daniels. Bwana Tabu, kindly unmute and say hello.
Wakenya mpo, jina langu ni Tabu O.W. Daniels. I am the Executive Director of Chama cha Maua. I am glad to be part of this conversation. Nawashukuru.
Thank you so much, Tabu. I can see on the chat box we have Miss Ann Kadhurima from ELOG. She's saying hello, but she has an issue with her audio. Welcome, Sana Ann. We also have on board someone logged in as Samsung Galaxy 578. Kindly unmute and say hello, and also tell us your name. I see. It's like we cannot get to the participant who has logged in with Galaxy. So we will just move on.
Hello.
Okay, there you go. Yes.
Sorry, maybe kulikuwa na makosa ya kuandika.
Yes.
It's not supposed to be Galaxy, it's supposed to be Mohammed. Mohammed Abdi from Economic Property. Glad to be here.
Thank you so much, Bwana Mohammed, and welcome on board. Right now we go into, I can also see we now have Miss Jackie Maribe online. Jackie, kindly unmute and say hi to everyone. Jackie, if you can hear me. Okay, it seems we cannot get to Jackie. Sahara, kindly unmute and say hi. Okay, it seems that they cannot get to us. But okay, I can see Sahara is on the chat box. She has said hello and she's following the discussion. So Zahara, welcome on board also. So without so much further ado, let me welcome our Executive Director, Mr. Franklin Mukwanja, to do the opening. And also welcome on board our facilitator for today, Ms. Roslyn Odede, and our panelists also, Mr. Honorable Brian Osodo, sorry for that, and also our moderator, Ms. Jackie Maribo. Welcome sana, Bona Frank.
Thank you, Maureen, and good morning to all the participants. I am unfortunately not in a very good location to use my video, so please bear with my voice only for now. So we have organized this forum for the political party leaders to look at mainly the two referendum proposed legislations before two committees now. The CIOC, the Constitution Implementation Oversight Committee, and the Justice and Legal Affairs Committee of Parliament. We are not just looking at these bills from the context of the proposed referendum under the BBI framework, but we're looking at it for posterity. As you may appreciate, this country does not have a policy and legal framework for referendum. And it's a very important piece of law that political parties need to have a spotlight on. And it's our duty as CMD then to be able to offer these opportunities for political parties leaders to keep apprised of such developments. And this is one of the pieces of legislation that we are keeping an eye on to ensure that the preparedness for this election cycle is much better than the previous ones. And political parties playing a central role and being the main stakeholders in an electoral process, it's important that you are ahead of the game, you are ahead of everyone in terms of readiness and preparedness and the level of knowledge to be able to aptly guide your membership and also help the electorate participate meaningfully in the democratic endeavors. And this is really the reason we have this engagement. You may be already familiar with the two pieces of proposed legislation. If you are not, that is why we have brought in Wakili Roslyn Odede to help illuminate into these provisions to do two things. One, for awareness, of course, and secondly, when it comes to that time, there's an opportunity for submitting memorandums and public participation, then party members are in a position to ensure that they are making meaningful contributions to these very important legislations. So without much further ado, I think I'll hand it over back to Maureen to work with the moderator and the resource person in this, and mine is to wish you very fruitful deliberations. Thank you very much.
Thank you so much, Frank, for those opening remarks. We now go to the presentation from Ms. Roslyn Odede. Welcome, Sana Roslyn. See.
Good morning, everyone.
Good morning.
Kindly share your screen
Good
now.
morning. Good morning.
Morning.
Can you see the screen?
I can see you. I think it's not yet. We are seeing your documents folder.
Okay. Just give me a minute. I hope it's visible now.
Not quite.
Not quite.
Not yet.
Not
You
yet.
still have the folder, no screen.
Oh, it's the folder which is still there.
Yeah.
Okay. Let me.
Meanwhile, allow me to just hello. I was having a problem with my audio. I'm on Dano Soda from Migori County Assembly.
Roslyn, let me come back in like 2 minutes, please.
Okay.
All right.
In the meantime, Wakili, how are you?
Tabu, how are you?
I am good, Mlamamba. Si unitupie kipande cha mamba kilichokaushwa.
Nitawatumia.
Tafadhali niweka kwenye mtandao tuanze kugawana. Mafuriko yapo hayapo?
Mtalewa na mamba alafu mtafanya mkutano.
Wasema nini mzee Ruhu? Bwana Moite Abakiro. Bwana Moite Abakiro.
Tabu Joka Noi, how are you?
Joka Noi. I am good.
Habari ya siku nyingi bana.
Nashukuru ndugu, sina ubaya. Labda wewe niambie.
Niko salama kabisa.
Nakuona usalama.
Nipo.
Hivyo ni vyema.
Leta mazuri kutoka na Kenya, chama cha maua.
Maua yanawiri, twasema reject BBI.
Kule hamtaki mzaha.
Mna. Kenya hii haitutaki watu wa kuchezea.
Kaza kabisa.
Wewe ndugu yangu, wacha debe liamue. Mwajidai ati mko na milioni 5.2. Taleta zetu milioni 10, mtashangaa. Wakenya wameamua hawataki mchezo. Watu wafa, hospitali hazifanyi kazi. Nyinyi ndio hao tuna So what is our
It's actually unfortunate.
very leadership has gone to the door.
Are we good to go now?
And we must. But we still have your folder.
It's still the folder.
Nothing has changed, Maureen.
There you go. Hapo uko sawa.
So, okay, good morning, everyone. Once again, I hope we can all mute our mics so that there's less interference as we proceed. Once again, I hope we can all mute our mics so that there's less interference as we proceed. So, okay, good morning, everyone. Why is that being repeated as an echo, Maureen?
We've muted the person who was giving the feedback. You should be good to go.
Oh, okay. Thank you. Thank you very much. So thank you very much, ladies and gentlemen. Again, once again, it's a pleasure to be here with you and to discuss legislative issues. And today we are looking at the referendum bills. Now, there are two referendum bills pending in Parliament. One was initiated by the Committee for Oversighting Implementation of the Constitution, and the other was brought by the Justice and Legal Affairs Committee of Parliament. Now, both of these two bills actually have gone through the second reading and have actually called for public participation. But beyond the second reading and calling for public participation, it is not clear whether they have gone through the third reading. And this might be because there's need to reconcile the two bills. It would be foolhardy of Parliament to be passing two contesting bills at the same time as separate bills. So I have a feeling post the second reading and the call for public participation, which they did call for at least 4 weeks apart as committees, I think the two bills must be in for reconciliation, redrafting, and merging into one bill. But at this presentation, I'll give you an overview of both bills because so far we have not seen a single merged bill presented, and it is not clear from the parliamentary website what is happening. But the second reading for both bills has actually taken place. Now, before I look at both bills, I'll give you a quick overview of the legislative process in Parliament, because some of you might be asking, what's the second reading and what's all this I'm talking about? Now, what happens with legislative process is if you want to introduce a bill, you have to first draft it. And in drafting it, it must have the memorandum and objects of that bill and present it to the Speaker's Committee, who will look at it and confirm that it complies with the regulations and it is a bill that's in accordance with the law. And then it will present it to the Speaker, who will introduce it into the Assembly at what is called the first reading. Now, the first reading, no motion or question is put. The bill is merely introduced into the House and given a tracking number and assigned back to a committee to look at. So that's the point. It goes to the relevant committee. And when it goes to the relevant committee, the committee calls for public participation. So that's the stage at which we look at it and call for. No, not at that stage. It goes to the committee so that the committee aligns it and understands it and brings it to the House for a second reading. Now, at the second reading, the bill is looked at, a vote is taken only on the general outline and not the contents of the bill per se. And once it is approved that it's a bill that can be debated and discussed at the second reading, it is then taken back to the committee, and it is at that point that the committee calls for public participation on the bill. So that's what has happened in this stage. So after the public participation, the committee may redraft the bill and resubmit it to Parliament for a third reading. Now, at the third reading, what happens is we go into what we call a committee of the whole House. Now, in the committee of the whole House, you will see the speaker reading every clause of that bill if you watch parliamentary proceedings, and they will say, they'll read a clause, it will be talked about, and they will either pass that clause. So they do a clause by clause reading and passing of the bill. So that's what happens at the third reading, and post the third reading, any amendments to be made are made, and then the bill is drafted for finality and sent to the president for assent. Now, when it is sent to the president for assent, the president can either assent to it in whole, or the president can can give comments on what he doesn't like and send it back to Parliament for reconsideration. Or the president may assent to it as it were and pass it, and it becomes law. So it can either go back to Parliament for reconsideration, or it can be passed as it was presented to the president. After it is sent back to Parliament, if Parliament considers it again, they can tell the president we are not making change, or we are making change, and then the final bill becomes a bill. Post the third reading and presidential assent, then there's the commencement. Some bills commence on the day it is assented to, and that is clear. Some bills are set aside to be commencing at a later date. And if this is the case, it is clearly stated on that bill that the commencement date shall be day XYZ. So that is made clear. So that's just a quick overview of the legislative process. It wasn't part of today's discussion, but I thought it was important so that when we are discussing bills pending in Parliament and discussing how to fast track them, we know what the processes are and what's going on. Now, it is said that a bill cannot go through the first, second, and third reading on the same day. They must be staggered at the same session, not day, at the same session. So that is also a provision in the standing orders. Now, let's look at the two bills. We'll start with the one of the Justice, Legal and Affairs Committee of Parliament. Now, they propose that a referendum bill be initiated, and the purpose is to consolidate law relating to referendum. So you will see that the purpose of the JLAC bill does not just relate to referendums relating to amendment of our constitution, but they broaden it to include any other question that may need a referendum. So it is not just relating to amendment of the constitution. Now, insofar as it's not inconsistent with the provisions of this proposed bill, the Elections Act is deemed to apply to this one as well. So these are provisions around like election officers and polling stations and things like that. Those will be borrowed from the Elections Act for purposes of the referendum. Now, where there is need to conduct a referendum, the president is required to forward instructions to IEBC within 14 days. Now, if you look at the Constitution, they say that after a bill is passed by the County Assembly and the National Assemblies and sent to the president the president is supposed to instruct IEBC to conduct a referendum, but the Constitution doesn't give him a timeline. So this bill proposes to introduce a timeline of 14 days within which the president must forward that matter to IEBC to conduct a referendum. Now, the bill also makes recommendations around the 1 million signatures. The Constitution merely says that a referendum by popular initiative will be initiated once the promoters get 1 million signatures to support it. It doesn't qualify anything around the 1 million signatures. So this bill proposes to qualify it by saying that not more than 1/3 of those signatures should be from a single county, which means you must move around. And secondly, the second qualification is that the signatures must be spread around at least 4 counties in the country. So it brings in a qualification for the 1 million signatures to clarify what the Constitution provides. Now, it also recommends that the bill and the names of the promoters and the names of the 1 million people who are supposed to have supported it should be published and made public so that everybody is aware who initiates the bill, what is in the bill, and who supported the bill or who moved for the popular initiative. So that should be made public by publishing it in a newspaper. The county assemblies have 3 months to approve the bill, and that's in line with constitutional provisions. And then once the counties pass the bill, and the requirement in the Constitution is it must be passed by at least half of the counties. So at least 24 counties must pass the bill. And the counties that pass the bill must issue a certificate to the Houses of Parliament, to both Senate and National Assembly, confirming that they have passed the bill. Now, the presumption therefore there is that if they do not pass the bill, or if no certificate is received in the Assembly, in the National Assembly and Senate within the 3 months, then the bill has failed. But should the Assembly, should National Assembly and Senate receive the certificates from 24 counties, then they can begin to deal with it. So even if a county does not deal with the bill, but the 3 months expires, then that draft referendum bill is deemed to have failed. Now, Parliament is required to conduct public participation before passing the bill. This is, I think, a requirement for all bills going through Parliament, but I think it's necessary to put it here because the constitutional provisions are not clear on the need of need for public participation before passing of the bill. Now, if both houses of Parliament do not pass the bill, then it lapses unless it relates to a matter under Article 2551. So if the bill is in regard to amendments that are not part of 2551 and the House do not pass it, then the bill collapses at that point. But if the matter is not passed by Parliament, but it relates to matters under 2551, then it does not collapse. It must still be referred to a referendum. So what are these matters that are there under 2551? These are matters for which a referendum is necessary. An amendment cannot be made without having a referendum. And these include the supremacy of Parliament, the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people of Kenya, national values contained in Article 12, our Bill of Rights, the term of office of the President, the independence of the judiciary, functions of Parliament, devolved government object and structures, and provisions relating to the amendment of the Constitution. So those are the Article 2551 issues that must be subject to a referendum, whether passed by Parliament or not. But if the issues were not subject to referendum, then the bill collapses at that point. So that is actually in line with the constitutional provisions that we have in Article 255, 256, and 257. If the bill passes, then the President is required to request IEBC to hold a referendum, and IEBC must hold that referendum within 90 days. If the referendum passes, if the process is subjected to a referendum and it passes, the bill proposes that the President must assent to it within 30 days. Again, that is actually a constitutional provision, and the bill is just echoing what the Constitution says in regard to that. Now, the JLAC introduces an interesting provision when they talk of the drafting of a divergent bill. Now, they say that when they provide that when the promoters of a bill come up with a draft bill for amendment of the Constitution, then anybody opposing it can actually develop a divergent bill. And when they develop their divergent bill, both bills are subjected to parliamentary approval. And when they are subjected to parliamentary approval, Parliament can either approve one or the other, or approve both, or merge the two. This is a very interesting proposal because then it really takes the ambit away from the promoters. It allows diversity in the process of referendum, and a very, very interesting proposal. It would be interesting to see how this plays out in actual practice. If both are approved, a voter may only vote for one option. That's the provision. And if a voter is not certain, then they would be in a dilemma here because they would not be able to vote upon both bills that are presented. Now, I said earlier that this bill provides for amendments other than just an amendment to the Constitution. And you might be asking yourself, so what other referendum would we be having? Not amendments, referendum, not just the Constitution, but broader than just the Constitution. So you might be asking yourself, what other referendum could we have? Now, we could have referendum even at the county level, asking questions around what processes that the county has. Recently, when America had its elections, they were even doing a referendum on whether to legalize marijuana for medical purposes. So we can have referendum for broader issues other than just amending the Constitution. And that's what this bill is envisaging when it provides for that. So it's actually saying there's leeway to have referendum for anything else other than just amending the Constitution. Now, once a bill is supposed to be debated upon or taken for referendum, it is the duty of IEBC to frame the question and send it to Parliament for approval. So they're introducing a process of parliamentary approval of the question to be subjected for referendum. The question must have a yes and no option. It doesn't provide for a multi-question referendum. And I think that's something that we need to be considering, whether to have a multi-question referendum or just a single question referendum. The approved question is to be published together with the notice of the referendum, and referendum committees can be formed by those supporting yes and those supporting no. So people can form referendum committees around those, and the committees can be at national level and at the constituency levels. Referendum committees must be registered and they bear their own costs. If public money is used, and then it must be shared equally to both of the committees. Now, the referendum succeeds in line with the constitutional provision. It says that a referendum succeeds if 20% of registered voters participate and where a simple majority is achieved. So 20% of registered voters in at least half of the counties. That means 24 counties. So that's what the threshold is in the Constitution, and it's imported into this bill. Once we have a referendum, one may file a referendum petition, and the petition must be filed within 28 days. Sorry, it reads 8 there. It must be filed within 28 days and concluded within 6 months. The petitions are to be had in the High Court as a first instant court and must be heard by a 3-judge panel. The decision of the High Court can be appealed to the Court of Appeal, and the Court of Appeal case must be concluded within 6 months. The appeal and petition are a stay of the petition, the referendum results, and the referendum results will not be announced until all the court processes are concluded. Now, anyone wanting to petition against the referendum result must deposit 1 million shillings as security for costs. This is a barrier because it means if you don't have the 1 million, then you cannot access the courts. But it's open to discussion, but these are things that are probably passed and already going through the 3rd reading now. The referendum voting materials are to be kept for 6 months. This is for purposes of waiting for the court process to be concluded. Because when the matter goes to the Court of Appeal, they only go to appeal on points of law, and therefore things like scrutiny of the ballots and counting of the ballots will not happen at the Court of Appeal level. Now, referendum officers who commit offenses can be fined up to 1 million Kenya shillings or jailed for up to 12 months or be subjected to both imprisonment and a fine. Election Offences or Act principles apply here. So all the offenses we have in the Elections Offences Act will apply to a referendum. The Electoral Code of Conduct also applies to referendum. And then all the provisions that relate to referendum in the current Elections Act will be deleted so that only this act bill, if it becomes law, will be operative in terms of elections and referendum. Now, when it comes to the CIOC bill, the CIOC bill now just focuses on amendments to the Constitution. It doesn't broaden itself to other amendments other than the Constitution. And this can be explained that by the fact that the role of this committee, COIC, not CIOC, this committee is to oversight implementation of the Constitution. So it would not be looking at things other than the Constitution. So it's understandable that it would focus just on amendments to the Constitution. Now, it requires IEBC to make regulations for verification of signatures because right now there are no clear regulations for verification of signatures. Even though we know that IEBC is a repository for all our data and have our signatures, we need clear regulations for that. And I think that's a plus for this bill. The commission, it gives the commission 90 days to verify signatures and reformat the draft bill where necessary. So it's giving IEBC a very broad mandate there to redraft the bill if necessary, and 90 full days to do this process. So that expands the window of the referendum process by another 30 days over the current 8 months that we have. Now, the reformatting must, however, not alter the substance of the bill. So the IEBC must be careful that the substance of the bill is not altered when they do this. The bill should then be submitted to the counties, and they introduce the requirement that counties carry out public participation by publishing a summary of the bill in newspapers and calling for comments. Now, when the bill is in the counties, it must be introduced in the assembly as a motion, and then it must be debated and voted upon. And it is won by a simple majority. As long as it receives a majority of votes in the assembly, then it is won. The county assembly cannot amend, draft, or improve the bill. It must pass it as presented to him. Now, for this bill to pass through the county process, it must be passed by at least half of the counties, which means 24 counties must pass it. And again, this is in line with constitutional provisions. County assemblies that pass the bill must deliver up a certificate confirming this to both houses of parliament. And as soon as both houses of parliament receive confirmations from 24 counties, they must, within 24 days, introduce the motion for consideration. And parliament must then consider the bill, and where they pass it, then they must notify the president, who must then notify IEBC to conduct the referendum. IEBC must conduct the referendum within 90 days, and within the first 7 days, it must publish the question. So it must be able to identify and publish the question within 7 days, and then within 14 days of receiving the certificate from parliament, they must also publish the question and the date and notice of the referendum. So 7 days for publishing the question and 14 days for publishing the notice of the referendum. IEBC should assign symbols for each question, but the symbols should not resemble those of any political party. I'm sorry, there's a spelling error there. So that is it, they must assign symbols. But this makes me wonder, I thought at one time we had symbols of orange and banana, and orange ended up becoming a political party symbol. But maybe it's the political party that borrowed from the referendum. So that was not in error on the part of IEBC. So then registration of voters is suspended from the date of publication of the date of the notice of referendum up to the day of polling at the referendum. So there'll be suspension of registration of voters during that period. IEBC is required to conduct voter education from the date of publishing the notice. And in so doing, they may partner with other people other than itself to help it conduct voter education. Every question to be determined should have a yes and no answer. Now, this introduces the possibility of more than one question. This introduces the possibility of a multi-question referendum. And I think this is progressive and something that can be useful, because sometimes you look at the referendum issues and some are okay and some you feel are not okay. And if there was a multi-question referendum, we would have a better answer. So this is what is being proposed in the CIOC referendum draft bill. Then they provide for appointment of returning officers and referendum officers, and this is to be done in line with how election officers are appointed under the Elections Act. They also provide that there be a register of voters, and the register of voters to be used is the same register that is used for general elections. So that is what makes up the register of voters. For purposes of voting, a voter must produce identity documents, either in the form of a passport or an identity card. IEBC is given the power to determine and publish the polling stations and areas for purposes of a referendum. They do not need to be in line with the constituency polling stations, and whatever they publish shall be what will be used. The referendum committees, they provide for establishment of referendum committees, and these can be formed at national level and constituency levels. They must also register and give details of the agents and officials that shall monitor the referendum process. Every committee is supposed to bear its own costs, and it also provides that no polling area shall have more than 2 agents oversighting the referendum process. Referendum committees are permitted to carry out campaigns. Now, there's a distinction between campaigns and civic education. IBC will be carrying out civic education. Referendum committees will be campaigning for their position, because the committees are aligned to either the yes or the no camp. So that's how the committees will work. Campaigns for referendums stop 24 hours to polling. Voting is to be by secret ballot, and the question on the ballot should be published in both English and Kiswahili languages. It requires IBC to make provisions, special provisions for those in diaspora so that they're able to vote, for emergency workers who may not be able to take time off work to go and vote at the polling stations, for people with disabilities so that the places are friendly and they are able to access the polling stations, for inpatients in hospitals, for people who are in homes for the aged, for pregnant mothers, and people who are in prison. Anybody who wants to observe the referendum must be accredited. Now, after the referendum is conducted and observed, the results are to be announced at every constituency and then forward to the commission headquarters. The commission is not required to announce the result until the result of every constituency has been received. However, where they are not able to receive results from all constituencies, but in their opinion, if they announce the result, it would not affect the outcome, they may then declare the result even before receiving results from all constituencies. IBC must then declare and publish the result within 48 hours of close of polling. So within 48 hours, we must have a result, and it must also be published in the Kenya Gazette. The publication must include the results from each constituency, and the publication must also contain the certificates declaring what the result was. So there are 3 requirements there for the IEBC. Now, after the result is declared, one may petition the result in the High Court. A petition is to be filed within 21 days, and it must be heard by a 3-judge bench. Where no petition is filed, the declared result becomes the final result. But where a petition is filed, then the result has to outweigh the outcome of the petition. A petition must be served upon the respondents within 7 days, and the petitioner must publish the notice of the petition within 14 days. The registrar must immediately inform IEBC that a petition has been filed and serve them with a notice of that petition. The petition must be heard and determined within 6 months. The decision of the High Court is final. There is no leeway to appeal this decision in the Court of Appeal. and the registrar must notify IEBC of the final orders and finding of the court in relation to that petition. If the referendum is declared void, then a fresh referendum must be held. If the referendum is not declared void and is not cancelled, then the referendum results are held and are declared as final results. This bill also provides for deleting of sections of the Elections Act that relate to referendum, just like the JLAC bill. So in conclusion, those are the provisions. They're very, very short and brief bills. So they're both very progressive. They have progressive clauses, but there's a need to merge and reconcile the two. And I hope that's ongoing as we speak. The differences are there. There are differences, for instance, the number of days of filing petitions. JLAC provides for 28 days, while CIOC provides for 21 days. That will have to be reconciled. JLAC provides for more than just one referendum. They provide for referendums in the counties and referendums on any other question that Kenyans think they need a voice on, while the CIOC only provides for amendment to the constitution. So the two issues can be merged so that we have one progressive referendum bill. JLAC provides for appeal to the Court of Appeal, while CIOC says that the matters terminate at the High Court. There may be sense in terminating matters at the High Court, because if the matters were to go to the Court of Appeal, the cases would last at least 6 months, and that would be really, really long. CIOC gives IEBC 90 days to verify signatures, which is a very big window. There's no similar provision given by the JLAC bill. CIOC provides for public participation at county level, while JLAC provides for public participation at parliamentary level. JLAC gives Parliament power to amend the bill, while CIOC doesn't give that possibility at all for amendment to the bill. Then JLAC provides for a divergent bill to be developed, and that's a very interesting proposal on which I'd really like to hear your views after this. CIOC also introduces the possibility of a multi-question referendum, which again is a very progressive provision, and I'd like again to hear your views on that. So both bills have good provisions, but there's need to fast track it through the parliamentary process, as we have a referendum coming up soon and we don't have a referendum law in the country. There's a lacuna in terms of referendum processes in this country. So it's very, very important that this is one bill that is fast tracked as we go forward with the referendum processes. Thank you very much, ladies and gentlemen.
Yes, a presentation. Okay.
Thank you so much, Roslyn, for that elaborate presentation. Actually, I've just learned a lot. I didn't know there were so much differences between the JLAC and the CIOC referendum bills. We now go to the Q&A session and the panel discussion session, and I welcome on board our moderator today, Ms. Jackie Maribe, and also Roslyn again. Welcome to the panel discussion, and also Honorable Brian Osodo. So without so much further ado, I'm kindly requesting that we mute our mic so that we do not interfere with the meeting as we go to the panel discussions. And I also encourage us to, if you have a question, you can just type it in on the chat section, or also raise your hand on the chat section, and we'll just be able to see you. So without so much further ado, Jackie, karibu sana to guide us through the panel discussion. Thank you.
Thank you very much. Good morning, everyone. Can you hear me?
Yes, Jackie, we can hear you.
Thank you very much, Rosalyn. That was a very enlightening insight into what we're facing right now between JLAC and CIOC. I'd like to welcome all of you now to our Q&A discussion. If you have any queries between what the JLAC provisions are offering and the CIOC provisions are offering, please do let us know. I'd like all of us to mute our mics first of all, but if you want to raise a query and you're not being heard, please type in your question and I'll be able to raise it. So let's begin by Rosalyn. I want to ask you, between the two provisions of a multi-question by COIC and JLAC of a yes or no question. Kenyans are faced with, you know, these two very broad decisions. What then would be the better outcome? A multi-question decision or a yes or no decision, Rosalie? Honorable Rosaline, can you hear me? All right, I'd like to put the question to the plenary. What do you guys think about a multi-question versus yes or no question?
Jackie, for that, I think we can maybe direct the question to Honorable Brian as we wait for Rosaline to rejoin.
Yes, please. Honorable Brian Osodo, MCA Kachienga Ward. Brian, are you with us?
Hello, Madam Jackie.
Yes, Brian.
So Brian Tabu is the one.
Yeah.
I'm just wondering why we are changing goalposts. Council Odede made his presentation, and we are supposed to make our responses. Some of us have our hands up. Now, Brian, who appears not to be having anything to say for now,
Okay.
being coerced into saying, why don't you deal with those of us who are ready to ask questions? So you bring in those who are thinking.
No, Mr. Tabu, go ahead.
Sorry.
Mr. Tabu, go
Sorry. Jackie, did you ask me a question? Did I miss something?
Yes, Rosaline, we were asking, but we had one of our participants wanting to comment. We were asking between the COIC multi-question provision and the JLAC yes or no provision, which one would be a better option for Kenyans at this moment, Rosaline?
I think, hello, I think that's clear that a multi-question referendum gives more options to the people. When you have a multi-question referendum, you're able to reject what you do not like and to accept what you like at the end of the day, as long as you answer just yes or no to each of the issues. Let's take the draft constitutional amendment, the Constitutional Amendment Bill 2020 that we have currently. Now we have a lot of issues. So some issues, some people probably like the fact that we are going to have nominations for a lot more nominations in the National Assembly. Some people probably feel that's abandoned. But at the same time, I feel like 35% allocation to the counties is a good thing. So I want to shoot down the large size of parliament, but I want to accept the proposal of 35% to the counties. So you're looking at it and saying, if there was a multi-question referendum, we would keep the good and reject the bad. But when it's a single question referendum, we are going to either reject, as Tabu, was it Tabu says they are rejecting, reject the entire bill or accept the entire bill. So remember in 2010, we said, let's accept this bill, ingawa iko na makosa, will tutarekebisha baadaye. 10 years later, those issues why we wanted to reject it in 2010 are totally forgotten and are not even being looked at now, but we are amending other things. So accepting wholesale as a single question makes us accept things that we do not need. And I think it is better to have a multi-question referendum. The only thing is it might overburden the voter. The voter may not be having the capacity to vote along the way for all those issues. But I think with adequate civic education, a multi-question referendum is much, much better than a single question referendum. I hope I've answered that adequately.
Thank you, Rosalie. Mr. Tabu Daniels, your thoughts?
Jacqueline, I also want to talk. Huh?
Mm-hmm.
You allowed me to talk.
Yes.
Has he done with the
As Tabu is preparing to talk.
I can talk.
Please go ahead. Jacob, go ahead.
Yes, thank you, Jacqueline. Let me first say hello to all of you. This is not the right time actually to do. I totally agree with what Tabu has said. Myself, I'm going to mobilize a Democratic Party for rejecting this bill. First, this is not the right time to do these things. People that are dying, instead of looking for money to get medicine for the people of this country, we are using that money to look for power. First of all, it is not the right time. Two, it is just the election, it is just 18 months to elections, general elections. Why, what is in a hurry having this referendum? This is a time we can look for money and pay our doctors and look for medicine to get our people to get them this virus, to control this virus. Therefore, I am supporting 100% what Tabu says, that we are going to mobilize all of these countries. We are going to walk. We are not going to drive, to walk, to mobilize Kenyans to reject these things. That is what I wanted to share with you, all of you here. Thank you.
Jacob, are you saying therefore that there should be mobilization?
Only what we want is just adding this, that 5% to the county, so that the counties, they can do whatever they want to do. Since they are saying that they have no money to pay their doctors, they have no money to do whatever they want to do, all those things. It is in our recommendation that 5% to go to the counties. That is only what we can agree with this bill, and also create of the leader of opposition. Only those two items. Otherwise, the other things, we don't have to increase parliament from 210 to 360, giving Kenyans another burden which we cannot going to avoid to bet, and our people were dying. So what kind of leadership? We are leading the country in a hell. I don't know, we have never seen something like that in our life. So we are totally rejecting the whole things.
Right, Jacob, I also see Justice commenting and saying Kenya has its priorities upside down and Kenya is not ready for a referendum. What are your thoughts?
Actually, it is a wrong time. Look, people, they are dying. People, they are dying. I'm telling you how many days, every day you'll hear that people, they are dying. Forget this, for 6 people, 5 people announcing. Just go in the rural area. People, they are dying. I'm telling you, Jacqueline. I'm telling you, people, they are dying. These people, instead of looking for how we can control this disease, they are looking for power. I don't understand it. We don't understand, really.
Brian?
Yes, Jacqueline, I can hear you.
Your thoughts?
Well, allow me react on Jacob's sentiments, because I thought Jacob is already debating on the proposed BBI referendum. While here I think we are debating on the JLAC and CIOC referendum bills. Those are two different things that probably needs to differentiate. We are not talking about the BBI or the timing, but then it's very important that the two committees, I'm aware they met 2 days ago. I've not gotten the insights of the meeting or the minutes, but there are efforts that are being made probably to merge them into one document. As I've seen, there are not a lot of differences, while there are a lot of similarities. So it shouldn't really take much effort in merging it into one document so that we have a clear guideline on how to conduct our referendums.
All right. Rosalind, you wanted to comment on that? Rosalind?
Yes,
All right.
sorry, Jackie. I just wanted to make the clarification that Brian has just made, that we must distinguish what we are discussing today from the Constitutional Amendment Bill 2020. We are not today discussing the Constitutional Amendment Bill. We are discussing bills that have been before Parliament from before. They have gone through the second reading, and we are now waiting for the third reading. And I think they're in the process of merging the two bills before giving us another opportunity to participate in them publicly and then pass them. And the reason we are discussing these bills today is because they will affect any possible referendum that will be undertaken in this country. And because there's a looming referendum, it is critical to have a law in place before any referendum can be conducted. So let participants today understand that we are looking at the referendum bill and not the one that is going to go, not that constitutional amendment bill. We are looking at the law that legislates how referendums should be conducted, and not what is going to be taken into the referendum. So let's distinguish the two as we make our comments.
Absolutely.
I want also to make my comment. And I think I want to disagree with Haji, my friend, who is taking us out of the agenda today, and agree with the lady who has just spoken, that we need to wait and get these two bills merged, and after they have been merged, then we shall know the animal we are dealing with.
All right, Joel. All right. So let's stick to the issues of the two bills that are before Parliament, and I would like to get your thoughts on the appeal process. One, JLAC says 28 days and it can go to the appeal court, while CIOC says 21 days and it sticks at the High Court. What are your thoughts on that, panel?
Do the hands still count?
I think the hands stopped counting because now we are stuck.
Because I think we need to get a better way of portioning opportunities, because the hands, Tabu complained about it, and I'm seeing I've been raising my hand. I mean, seriously, we need to be better organized.
I think the moderator is the one failing us. Just to be precise.
No, absolutely. Just
blames.
No, give us your views. Give us your views.
Myself?
Kidi, I think Kidi Mwaga is, Kidi, you wanted to comment?
Well, yes, thank you very much. Well, I wanted to ask Madam, my senior and mentor, Hero Roslin, to help us clarify that if in the the Committee on Constitution Implementation, headed by Jeremiah Kioni, is suggesting that we conduct the referendum jointly with the next general elections. While some of the things we are seeking to, we were seeking to cure through the BBI process that was culminating into a referendum, were in part supposed to level the playing field for 2022. Isn't that suggestion in itself full of political mischief? Yes, I wanted Madam Rosalind to help us clarify that.
Kidi, if I could interject, I think what we're discussing today are the provisions by these two separate committees.
Okay.
And I think there has been an appeal to stick to that. What the Justice Legal Affairs Committee is suggesting or providing, and what the CIOC is also providing. So could we please first stick to that?
Okay. Okay.
how the different provisions, can either be merged together.
Okay.
Therefore, would be the way forward. So, my question was, between these two committees, the JLAC committee is suggesting that, if there is a petition, it should go all the way to the appeal court. Well, the
Yes.
COIC is saying it has only a 21-day window and it should stick at the High Court. My question is, what are your thoughts on that? Does it stick at the High Court?
Yes, I think I would cast my lot with the sticking to the High Court and having a shorter time frame for determination, so that one, the process is brought to a close within a short time, because in 2013 and 2017, we had disputed presidential elections and the Supreme Court was able to deal with these matters within the short time. So I think giving a High Court the 21 days would one ensure that we have the process brought to a close and people are able to move to other things, and does not let the room for the process to drag for so long. Thank you.
Madam Roslyn?
Yes, Jackie, thank you. Could we possibly allow a lot more people to air their views, and then I come in after that? Because I saw there was a kid, that Tabu wants to speak, Gesore wants to speak, and others. Could we allow them to just speak and then I come in after they have spoken?
I can see John Imoite, you have raised your hand.
Yes, Jackie, for a long, long time. Thank you finally for this opportunity. Very well. Permit me to make this observation even before I get into the content of today's discussion. Who else is talking?
John?
Yes.
Kindly, just a minute. Kidi Moga, kindly mute. Kidi, if you can hear me. Joel Ruho, kindly mute. Yes, please, let's all mute, as if you're not the one speaking, please mute, because so that we cannot interfere with the meeting. Sorry for that, Bwana Emoite, kindly continue.
Thank you, Maureen. Yes,
thank you, Maureen. Thank you, Jackie. Just a quick observation. I see there's a heavy appetite to discuss the content of BBI, such that even though today's discussion, even after clarification by Lady Roslyn, that we are discussing the referendum bills before Parliament, contributions are pouring in about the BBI. Could we please stick to the agenda of the day? That's my appeal. Now, onto the matters of the day. And here, Madam Roslyn, I beg your indulgence and pardon my ignorance. This is about referendum bills before Parliament. And the number one thing I see there is we have two bills. There's the CIOC bill, and then there's the JLAC bill, both of which are dealing with the same issue. My small question on that, why do we have two approaches to this? I mean, if both of these are driven by committees in Parliament, my thinking, perhaps about resource and other things, my thinking would then be it should have been one, or they should merge as soon as they can. Now, other than that, my other concern would be this. We do not have a referendum law in place. And we also do not have regulations guiding the verification of signatures. I don't know whether I'm right in observing that, such that I would want to say that if this were the case, we already have Chebukati receiving signatures for verification. And we are handling towards, I don't know, I hear things to do with some referendum thing somewhere in early next year or something. I don't know whether I would be correct in observing that for my countrymen and women, here we go again, doing serious things our usual way, such that this is a cat and a horse sort of thing. We don't even have regulations and laws in place, but we're proceeding with other things. I don't know whether my thoughts are okay. Madam Rosalie, please clarify my chaos. I have quite a bit of cloud in my mind on this. I'm done. Hello.
Thank you, John, for that.
Yes.
I was waiting for Jackie to take control.
Okay.
Rosalind, please go ahead.
All right, go ahead. Okay,
Yes.
I thought we were gathering a few more thoughts and then we move on, because maybe someone has something that improves on this, but it's okay. I will address John's issues. Now, John, indeed, we don't have a referendum law. And if you listen to some of the issues that were raised even while Punguza Mzigo was going on, people were saying, but if we're to have a referendum, how will this proceed in the absence of a referendum law? Because we actually do not have a referendum law in the country. But it's not all lost, because if you look at the Elections Act, and before we delete those, I think it's from section 60 to about section 80 of the Elections Act, all deal with a referendum. And they have some sort of provisions to guide elections during referendum. So it's not a total gap in terms of how IBC will conduct a referendum in the country. There is such provision for it in the Elections Act. So you will see that in both of these bills, there's a proposal to delete certain clauses of the Elections Act so that this becomes the only sole open law. So it's not a total gap in law. There is provision. I think we were just needing clarity as to some points. So we can actually conduct a referendum within the provisions of the Elections Act, as it were, today. So I hope that is clear as to that point. When it comes to verification of signatures, there are certain regulations for verification of signatures by IBC, but it is not clear that that is for purposes of referendum. So IBC has regulations for verifying signatures, especially around election times and general elections. So they can extrapolate these into the referendum, because as an electoral management body, they have the mandate to conduct referendum and elections. So they can use existing regulations to conduct and verify signatures for the next referendum. But it would only be tidy if we could have a law in place. And I don't know why Parliament has been dragging its feet. I think it was Corona, COVID, that affected them, because they were moving at a very fast pace, and then somehow they slid back into laziness. Now, when you ask, why do we have two bills from two different committees? I can only say it was sibling rivalry between the two, because the CIOC were the first to develop their bill. And if JLAC felt the bill was not good enough, they should have gone into the committee of CIOC and improved the draft bill at committee stage, so that they would come up with one bill. I think this was just sibling rivalry, just trying to show that we have more muscle than the other. And you can see the subtle differences. It's not big.
No.
So yeah, so it was just a case of trying to show ata sisi tuko hapa and we know how to do these things. But I don't see why we had two different bills. So that's what I would say for now, John. I hope I've answered you adequately.
You have, Madam Rosalie. Thank you. Thank you so much.
Thank you, John.
All right, Justice Anzaya.
Good.
Justice, your thoughts?
Could I reinforce that?
Yes, absolutely. Go ahead.
Oh yeah, I wanted to reinforce what Rosalind has just said. If you can remember, while we had the Punguza Mizigo bill that flopped the other day, And still, IBC was able to verify signatures and probably go through the processes in as much as it flopped. So there is no total gap. What the parliament now seeks to do is to separate election laws and the referendum laws so that we have a clear-cut structure on how to conduct specifically the referendum and then specifically the elections. So currently it is merged. The election laws, they imply that it goes together with the referendum, but there is need to separate the two. And I think that's what the two committees are working on. Secondly, just to reinforce that again, every committee or any person is allowed to bring a bill to the parliament, either from the public, from the external. It meets the requisite threshold by the parliament. So probably all the two committees were allowed to bring in, but I also reinforce the fact that there is need to merge them. The efforts are ongoing to merge them. I'm aware of a meeting that took place two days ago, just to merge them so that they come to one. Thank you.
Thank you. Thank you.
Thank you very much. I would like to hear what the ladies think, because we're not hearing from the ladies except from our learned friend Rosaline. Margaret, what are your thoughts? Margaret, Jadida, what are your thoughts? Anne, Hannah? Are they with us?
Jackie, I could probably go back to what Kidi asked, because I think we shelved his question.
Mm-hmm.
Yeah, Kidi commented about the timeframes, and I think to a large extent, I agree with you, Kidi. 6 months is pretty long for determining a referendum issue. Referendum issues are very emotive, almost as emotive as a presidential election. And keeping a court matter for 6 months and the referendum result pending for 6 months is a conflict trigger for this country that we live in. We know ourselves, we know how we operate, and I think your suggestion of a 30-day determination for referendum issues would be much, much more welcome, because we need finality and closure to some of these things. So we could probably say that referendum issues go to the Supreme Court and are determined with finality there within 30 days. I suppose that's one of the proposals we can carry forward from this meeting today, because indeed 6 months is very, very long. And being Kenyan as we are, I'm sure the referendum campaign period is going to be contested, is going to be volatile, and we need closure on the issue as soon as possible. So I take on board Kidi's comments about the time frame and how much time that should be allocated to this. I think that's what he asked. His other issue was related to the constitutional amendment or whatever, and is there political mischief? Kidi, I'll talk to you after this. We'll have that discussion. Thank you, Jackie.
All right, absolutely.
I tend to agree with you. I tend to agree with you, Rosalind. There is need to allow, the process to exhaust the various legal processes that are available in the Constitution. There's no need to restrict it only to High Court. We can allow it even go to the Supreme Court, but then include a clause that will restrict the timelines, probably to 30 days. But we should not really leave it at the High Court level. We should allow all legal processes at least to be exhausted.
Absolutely. Thank you for that, Brian. Benjamin, your hand has been up. Benjamin, can you hear us?
Yes, please.
Yes,
Thank you
Benjamin,
very much. Can you hear me?
Yes, we can.
You can hear me. Thank you very much. And I concur and thanks for, I'm not going to repeat what has been said from my chairman about the two bills and about the duration that is given for the referendum that has been said. But we have to understand that when we are talking of referendum, we are talking of people-based issues. And that is what is lacking in Kenya. You can see basically this, I'm sure I'm talking to senior party leaders, and you can see what the two committees have given, which are very good if implemented, but they're setting the threshold very low. I heard of something. It's the CIOC that is saying that 20 some percentage to come from at least 3 counties. I mean, seriously, 3 counties doesn't count for anything. Anything, assuming we wanted Nyeri, Tarakaniti and something, those are 3 counties and you'll find they're voting the same way. Anyway, the threshold is too low. And then we need to get goodwill if we want good laws. Because like we said, we are not talking about the current BBI issue, but you can see referendums in Kenya are not people-based, they're individual-based. Then we get, once someone has said what they feel in their hearts, all our leaders want to join them. And then honestly, we need to have a dialogue on this because the people in these committees are coming from these parties. We need to talk to our people, those parties with their members in those committees. Can we say that we can get them to do what is right for these laws? Thank you. For me, that's what I want to get. Sorry.
All right, thank you very much, Mr. Gisore. We'll put that question out there, but I again would like to appeal that we stick to the issues at hand, the 2 committees that have provided their provisions. So could we kindly just for today, because we'll have this discussion again, let's keep to what we're discussing between the 2 committees. Does anybody else want to comment before we move on?
Probably you didn't get my point. My point number 1 was
I
the
threshold.
The threshold of the recommendations from the committees is too low. Number 2, I'm appealing to the parties that the people that I sit in those committees are our own people. We need to have understood even better so that we can be involved while this is going even to the floor. Thank you.
Absolutely, absolutely, completely agreed. Anne, you wanted to comment on the matter?
Could I react on that? Or
Brian, you can comment. I just want to take a comment from Anne.
okay, it's okay.
Anne, are you with us? All right, Brian, go ahead.
Yeah, I just wanted to comment on that in the second reading, there's a place after the second reading now that the bill is allowed to go for public participation. Probably what Benjamin is raising are some of the issues that will be captured in a memorandum and presented to the committees, hoping that they come up with one bill, merged bill, then that's something that will be captured in a memorandum and presented to the committees responsible so that the threshold, at least the bandwidth is increased. So it's not too late and it's something that is possible.
All right, thank you, Brian. Margaret, you have something to add? Margaret, are you with us? All right, we can't seem to get Margaret. Jonah. When I see
me? Can you hear me?
Yes, we can hear you.
Can you hear me now?
Yes, we can hear you.
Can you hear me? Okay. Tell me. Yes. Okay. I've joined in late, but I'm in. Just trying to follow the conversation.
All right. Thank you, Jonah. Margaret.
Hello. Can you hear me?
We can hear you. Margaret, I think we can find you now.
Maggie, if you can hear me, kindly unmute.
Yeah.
Because I can see her speaking, but we don't seem to get her.
We can't hear her. Mr. Tabu?
Finally.
Apologies. we're many.
Hope it was not by design. We want to appreciate the presentation by Council Roglin Odede. It was very insightful. Hello? And Yes, I'm hearing. Hello?
Yes, Tabu, we can hear you.
I want to join colleagues in appreciating the presentation by Councillor Roslyn Odede. It was insightful and it simplified the two bills. I wish also to raise the following. Once the two bills that appear to be belonging to two sides of Jubilee, Tangatanga and Kieleweke, in terms of content right now. For one side is talking of multi-questions, which we know who is for multi-questions and who is for yes or no. Once they are merged and they become one, in terms of parliamentary procedure, how do we proceed? Is it assumed that when they are merged, they are no two bills because they have been living their own lives? To buttress what my brother Gesore asked, for purposes of approval of the debate of the referendum, 24 counties or a majority of counties are supposed to be involved. Signatures, only 4. One wonders why can't we have the same to apply? If it is 24 that we feel is what is acceptable in terms of taking us to the referendum, even the signature collection should not be at 4. My last question is the inclusion of a divergent bill. We know how we operate as Kenyans. And many a times it is myself against somebody else. I tend to read mischief in this clause that allows for a divergent bill to counter one that is already in process. Council, help me to understand whether there is a way of curing that mischief that I am seeing. All in all, given an opportunity, I would go for a bill that gives us options and reject what we don't want, and as we accept what is progressive. Thank you.
Right, thank you very much. Margaret, you want to speak to us?
Yes. I just want to reiterate and add voice to what my brother Tabu has said, that really there's a lot of confusion and Kenyans really don't understand what is happening with this bill. And I'm of the same view that we would need a bill that gives people a choice than just lumping everything together, you know? So we need council to just slightly elaborate on that, because as we talk to our people in the political parties, we also need to give them some directions. And if we are getting confusion at this state, what do we expect the people in the machinery to really do? So if Roslyn can actually expand on that, I would appreciate. Thank you.
Thank you, Margaret. Before I head to Roslyn, Stephen, can you hear us?
Hello?
Hello, Stephen, can you hear us? What are your thoughts?
Namashula, there could be several Stevens here.
No, you. We're talking to you, Namushule.
Oh, okay. Yeah, my take is that we have picked the stick from the wrong end. The big debate at the moment should not be at the mechanics of legislation and what have you. We have very fine brains to deal with that, and we are second to none in the whole world. the biggest devil, the demoniac in Kenya is the executive, which rigs elections, steals elections, and deals with the protesters and the postcode vote on them. And that's where the game for this BBI and the referendum business is. What are we doing to deal with this demoniac in the executive? We have to go spiritual, I think, to deal with this matter and to put things right. Otherwise, whether we talk about this JLAC bill or whatever bill, at the end of the day, it is the will of the executive, the pleasure of the executive that will prevail. How are we dealing with that? Thank you.
All right, thank you. I don't want to lock anybody up before I head back to Rosalind. Does anyone else want to comment before I give it back to Rosalind and Brian?
Jackie, can I just say something?
Yes, John.
Still on the issue of whether the law will say either yes or no, or you have multiple questions you're dealing with. Roslyn touched on this earlier, and her explanation was quite okay. It seemed to want to convince me to embrace the multiple question option. But I just wanted, just on that one, to ask, assuming there'll be quite a number, not just 3, not just 4, a number of them. And, you know, from what you hear now, it could more or less go that direction, that you have many of them, 5, 6, 7 questions you're dealing with. I'm just wondering at the possible logistical nightmare that could pose, in the sense that could it then work with a situation where you would say you limit, the law limits the number of questions, you cap it at, say, maximum 5, maximum 6, maximum 7, so that you do not have too many of them, then other than the fact that it possibly could confuse the voter. I'm not, buying that so much. The voters are intelligent enough, they can maybe walk through the rigmarole. But then the nightmare would then be with the tabulations and what and so forth and things like that. And knowing, to use the language that's been common in today's discussion, knowing the way we behave as Kenyans, can we then trust that these multiple questions would be sizzled, and that the actual vote representation, the will of the people will be represented, tabulated, and then given as such? Thank you.
Jackie, can I say something extra?
Absolutely, go ahead.
Thank you. Council, in 2010, when we had the red and green, the referendum committees were financed by IBC in terms of paying the agents. It is curious at this point that there is a proposal that the referendum committees pay their own bills or bear their own costs. I'm saying it is curious in this manner that going the way it is right now, those who are for Bibi Ngine is government. So how will we be convinced that government paid from its own pockets? Is it not our taxpayers' money that is going to be used, and then we are hoodwinked? For me, we need to go the 2010 way, that all referendum committees are actually facilitated by IBC, because this matter is not for an individual, It is what is equivalent to going to court on a public matter.
John looks very fascinated by that point before we move on. And we seem to have about 12 minutes or so to wind up.
No, I'm amused at the reference my very good friend Tabu is giving to the BBI.
Brian is amused as well.
Tabu, is this your?
May I also give an input?
Hold on, John. Let John finish, and then John, I'll come to you.
That then you can, John.
Yes, Tabu.
I just want us to embrace the fact that we cannot be retrogressing as a country. When we make a step forward,
yes,
we need to make 2 steps backwards.
Okay.
In the event of referendum, not necessarily this one of being in, there are going to be very many. but actually the law should actually take cognizance of the fact that a referenda is not about an individual, it is about us. And therefore, the taxpayer money, the one who is supposed to benefit from that referendum, if it will be single, then I was finalizing by saying, in terms of 28 and 21 days, for me, let's take the focus time visible, because we know in Kenya, the longer the issue takes, the more challenging it is. And the last of the very last, I want to bring in an angle to the behavior of our courts, and allow me to use a living example. When my party was filed her matter in the Court of Appeal, the Court of Appeal sat on the matter until when it was about 2 weeks to the lapse of 6 months. That is when it was determined. And by the time it was being determined, there were only 2 days left. The Court of Appeal is referring the matter to the High Court, because that is where the jurisdiction to hear and determine lies. When the matter is taken to the High Court, later on we are told that it was time-bound. I also want to ask to be very clear, where should this issue be? Because these appellant bodies, in one way or another, the current mischief will still play out. Thank you.
All right, thank you. Jonah, very briefly, you wanted to say something. We're about to wind up.
No.
Yes, can you hear me? Can you hear me?
Yes, Jonah.
Can you? Yeah, okay. I wasn't in when Rosalind was making her presentation, so I stand to be guided. But if I'm not wrong, the BBI can be divided into about 12 chapters. If I'm not wrong, I stand to be guided. What I know is that chapter
Jonah,
1 deals with the...
Jonah, please,
yes?
if you can hear
Yes?
me, we're
Yes?
not discussing about the BBI. We're
Okay.
discussing about the referendum bills.
Yes, that's what I'm talking about, Maureen.
Yes.
I'm talking about the referendum.
Yes.
Let me be clear.
Jonah.
I'm talking about the referendum, yes?
Jonah,
Yes.
we are speaking to the JLAC and CIOC bills.
Okay. I had an input anyway. Can I say it quickly?
Yes, very briefly, please.
Okay. You see, the BBI has 12 chapters, so that probably nothing could be lost in the 12 chapters. Maybe they can be brought together, because I know chapter 1, maybe notable issues, chapter 2, ethos, 3, maybe responsibilities and rights. I know chapter 6 is inclusivity. So probably the 12 can be merged, 2, so that we go for 6 questions in the referendum. I think Kenyans are smart enough to deal with the 6 pieces. Yeah. So that would be my input for the referendum.
All right. Thank you, Jonah. Lillian.
Yeah.
Lillian, if you can hear us.
Jackie. Yes,
Hi,
I can
Lillian.
hear you, Jackie.
Your input, Lillian, before we head back to Rosalind and Brian.
Yes, mine is just a quick one. I'm not sure, since Roslyn mentioned that the third mention has not been done, so probably this input will still have some impact. I noted that on the COIC proposals, what they're saying is that there should be not more than 2 agents in every polling station. And we know from practice that a polling station would even have more than 10 places to make the polling. So I think that would be restricting, considering the trust deficit issue that is right now in Kenya. It would be right to allow that there is an agent in every single line within the polling station instead of restricting to 2. So if there is room of making such an amendment within that bill, then I would wish that that proposal be considered at this moment.
All right, thank you, Lillian. Brian, because I think we're running out of time. Brian, what are your thoughts? I know a lot of questions, a lot of comments have been made, and I can see you have been taking.
I may react to 2 or 3. One is on the too many questions issues. I believe the spirit of the law is for the referendum question to be as simple as possible. So whether it's a yes or no or too many questions, the spirit should be, all those should be as simple as possible to the local Wanjiku. So I believe either way that the bill goes, whether too many questions or the simple ones, then it will be the mandate of the IBC to come up with regulations on how to govern those questions. And I'm glad in the JLAC they state that, is it the JLAC or I think the CIOC, they state that the question should be brought to Parliament for approval. So I'm glad about that, whether yes or no, or whether multiple, but the thing is, it should be as simple as possible to the local Mwananchi to make a decision on that. There was also a comment on the costs, and there was a clause probably in the JLAC where the costs, if any public fund is to be used, then it should be shared equally among the two camps, of which I think is the best way to go. Either if there is public funds, then the two camps share it equally, or if there is no public funds, then neither of the camps gets it. I want to agree with what Tabu says. Currently, as it is not a fair competition, as much as I'm avoiding to talk about BBI, because one camp is funded by the executive and the other one seems to be funding themselves. So I believe that's why we urgently need these bills to be made into law so that these issues are well captured or are well guided. There was also the issue of how to deal with the executive. I may not comment on that. Probably Roslyn will do, because I don't know. We really might not have a local standing on that as of now. Thank you.
Thank you, Brian. John is very fascinated by this discussion. I'm trying to understand why.
Yes, I am. There was just something. I even have made a comment on the charts. A couple of things, of course, to do with what we are discussing. There's quite a number of things that we could go over there. It's just this fascination that we have as a country, what I have seen in more instances than one. We are clearly discussing the referendum bills before Parliament, one by the CIOC and the other one by the JLAC. But there is this insatiable appetite to discuss BBI. So I don't know, maybe CMD needs to have a forum for that, because it's there in people's minds and people want to exhaust it. Something,
Absolutely.
Yeah.
Absolutely, I agree. And I think this is a discussion that we will have, despite us, today focusing on JLAC and COIC. Rosalind, I want to throw it to you as we wind up, because I see we have 3 minutes left. I know a lot of questions have been asked, Rosalind. If you're still with us?
Yes, I am.
Yes, Rosalind.
Okay, thanks. Thanks, Jackie. I'll try and run through them very quickly. There was the issue of the threshold around the 1 million signatures required to initiate a referendum. Somebody said the threshold is too old. The other person said they should be from more counties. I think this is just 1 million signatures to initiate. I don't even think it's necessary to get them from cross counties, because the gatekeeping occurs at the ballot when we now have the actual referendum. And at that time, we must have at least 20% of registered voters from half of the counties participating. So that's where the gatekeeping is. I think it shouldn't be so hard for someone to initiate a referendum if they need to, because it would be very difficult to spend money collecting signatures from half of the counties. And probably this would be an initiative of Wanjiko, who doesn't have that capacity. So I think we shouldn't make it too tedious to collect the 1 million signatures as provided in the Constitution. Benjamin, I agree with you around public participation. We need very broad-based public participation in this country. What occurs at parliamentary level and at county levels today is a sham and a joke. We really need to enhance and tighten our public participation processes, and we still do not have a public participation bill. So this is something maybe CMD needs to look for, because it's part of governance and it's part of giving us space in this country. So I think a public participation bill needs to find its way, and it should be broad-based, not what they say, putting things in a notice in the newspaper and saying send us memorandum, and we don't even know how they handle or tackle it. Sometimes we don't even see that notice in the newspaper. You're not even aware a bill is being debated, and it goes on. So public participation, I agree with you, Benjamin, needs to radically change in the manner it engages with us today. The multi-question, single question issue, I think we've discussed that at large, and we'll continue having that discussion, whether multi or single, but I think multi-question, personally, I think a multi-question gives us more room for choice and room to accept what is good and reject what is bad. Someone asked, I think it was Margaret, no, it wasn't Margaret. Someone asked, what happens after the bills are merged? Do we go back to like first reading? No, the merging is happening at second stage, and once it is merged, it will be taken to the committee of the whole house as a single bill. One committee will probably be able to report that we have withdrawn our bill at this stage, and another committee will present the merged bill to the committee of the whole house for the third reading. But I'm sure you can still send a memorandum to any of the two committees, and they will be considering it. I don't think they will reject it. The divergent bill issue is actually a thorny issue. It is actually allowing somebody to say no to your bill, to your draft bill, yet you're the initiator of the referendum proposal. So I think there's a lot of mischief in that draft bill, that divergent bill, and it's a way of knocking out the actual proposal for a referendum in the beginning. So that's something that we need to look out for. Margaret, I think, Margaret, your confusion is not around these draft bills. Your confusion is around the Constitutional Amendment Bill 2020. And you need not have confusion as at now, because we have not seen the question. The question will be published once IBC verifies the issues, and it goes through the county assemblies and comes back. So let us not disturb our brains at this point. The issues will be made clear going forward. For now, just debate the content of that bill with your constituents. Stephen talked about the executive and how we handle the executive. I think we must just continue doing things that using the tools that we have in the Constitution. Some of these tools are public interest litigation. Some of these tools are impeachment. Some of these tools are recall clauses. We need to use the tools that we have at hand to actually bring the executive to account. The problem with us in Kenya is that we wait for someone else to do it and complain in the background. The Constitution gives us tools, and we need to start using those tools to advantage. John, multiple single question again comes up. Assuming there'll be a lot of questions, I think Brian dealt with that in terms of the questions. No matter what, should be made very simple and understandable. The process should be easy to engage. But I think the principle of a multiple question cannot still be lost. IBC paid agents, that's taboo. Why can't they do it now? Taboo, I agree with you in principle on one thing, that if we make the campaign teams pay for themselves, we are actually allowing the teams with bigger money to steamroll the teams with no money. And I think that is really unfortunate. We need to make them be able to campaign on even footing, because a referendum is not a contest. It is something that is for the good of Kenya. We are actually creating or spoiling our country. So we need to facilitate both teams to be able to properly explain their side of the issue. So I think there's need for government to actually be funding the campaign teams equally. But even if they're funded, and those with more money will still inject more money into their campaigns. So you can't win this thing. I think sometimes it just keeps happening. So those are the issues. I think I've spoken to everything that was raised. Lillian talks of the 2 agents being too few. I think that's a provision that can be carried forward, because there's always space in the polling stations for more. A referendum is a serious issue. I think that's something that can be carried forward. Anne's question has not been answered. I don't think did Anne speak out? Anne is saying her question has not been answered, but I do not see a question.
Yes, she did. Anne, if you could kindly retake your question. Anne? Because I see you're saying your question has not been answered. Yes, Anne.
This is Maureen.
Okay, hi, Maureen.
Hi, I think Anne, she has an
Well,
issue
she
with
says
her audio.
she sent
but
on the
she,
chat.
yes, it's
Can
on
I
the
just
chat.
get it? Can I get it from the chat? Rosalind, she says her audio has issues, but she says IBC does not have a repository of signatures. How then will they verify the same once they receive the signatures? Since IBC is independent, why do they have to frame the questions, then send them to Parliament for approval?
Maureen, can you hear me, Maureen?
Yes, John, I can hear you.
Yes. Okay, just a small thing. I'm Jonah, not John. When she was giving my input, she said John. I'm Jonah.
Okay, Jonah, that is clear. This is Jonah Simba from LPK. Yes.
Yes,
Jonah,
yes.
Jonah, if you can hear me.
Thank you. Yes, I can hear you. I'm Jonah, not John. Yeah, that's it. Yeah.
All right. Can I take Anne Kathurima's question again? Rosalind?
I think I got it. She's asking around the signatures, and
Yes.
she's also asking around why Parliament has to frame the questions.
Thank you.
I think for the signatures, what I said is IBC actually has a complete database for all Kenyans who are registered voters. They have your full names, they have your ID details, and they have your specimen signatures. So they're able to carry out a verification. And indeed, they do it at every election before we go for election. So this is nothing new. When it comes to why Parliament needs to frame the question, and yet IBC is an independent institution, I think this is just, it's a proposal in one of the draft bills. It doesn't appear in both. And I suppose I'm trying to think for them that they were trying to oversight to ensure that the question actually reflects the wishes of Kenyans, so that
However,
IBC doesn't do this alone. But IBC being an independent institution should be given the leeway to do this on their own with finality, so that it doesn't become a political process and contest.
Rosalind, if I could interject, that was one of the JLAC provisions, that IBC should frame the question.
Yes, so that's what I'm saying. I think the idea was oversight, but IBC being an independent institution should be allowed to determine the question with finality and divorce it from Parliament, which might make it a political process and bring in politics into the issue. So those are my points. Thank you, Jackie.
All right, I hope everyone else is satisfied. If we have no further questions, because I know this is an ongoing debate that we will have. Anyone wants to raise a hand up before I hand it back to Maureen? We're good? We're all good?
Let's end there.
We end there? We're satisfied. Rosalind, you have made a very insightful presentation to us today, and we thank you for that. Brian, thank you for that. And all our participants, Mr. Tabu, Benjamin, John, Jonah, and Margaret, you have all made very insightful presentations today. Maureen, I hope we can have another discussion, because I see there is a thirst to discuss the BBI, not just the JLAC and COIC provisions that are there. So I'm hoping that we will have another discussion on the same, but right now I would like to hand it over to Maureen from the Center for Multi-Party Democracy to close for us with a vote of thanks and a way forward, Maureen, because this is a discussion that is ongoing. Maureen?
Yes, Jackie. Thank you so much for moderating this session. And let me take this opportunity to thank everyone, all the participants who took time out of their busy schedules to attend our meeting today. Let me take this opportunity to also thank our facilitator, Ms. Roslyn Odede, for taking us through the two bills and elaborating more on their contents, and also giving us the answers and the explanations that we need to understand the contents of these bills. And also a big thank you to Honorable Brian Osodo, MCA Kachemu Ward, Migori from Migori County. Thank you so much, Mheshimiwa, for just tuning in and to help us discuss these bills. Also to Jackie Maribe, thank you so much for moderating this session and also for honoring our invite to be, our moderator for today. So as a way forward for us here at CMD-Kenya is just to encourage, all of us to be vigilant. Once these bills have been, merged and they have gone to this for the second reading, and we as the public are being called upon to give our input into the bill, I'm just kindly requesting that we can actually come together as one. You can send your input to us here at CMD, and we will, put them together and maybe present them to Parliament once these bills go for the second reading. And also even you as an individual can actually send the same inputs to Parliament for consideration. So yes, we intend to hold further discussions on the same, because until we have the legislation in place to guide the conduct of these referendums and other political processes that are still pending in Parliament, we here at CMD Kenya will endeavor to hold these sessions to just capacity build everyone on the contents and the processes that have to be put in place. Otherwise, from sisi hapa at CMD Kenya, asanteni sana and kuana jioni njema. But just
one more thing, Maureen, before you go, one more thing, please.
Yes, Brian, yes.
Could you please share the notes from Roslyn to our emails? It was very insightful. I believe it will inform even our
It was very insightful, right, Brian?
Yes, exactly.
Yeah, sure. Please share the notes. Please share the notes.
Yes, that's a sure thing. I will just share the presentation to your emails, and then now we can, you can also muendelee kuspread huko nje, injili on the contents of these bills and what needs to be put in place. Otherwise, mkuwe na jioni njema na weekend njema. Asanteni sana.
Asante sana, Maureen. And I think as a closing note as well, I think we should take it as an individual responsibility, even as whatever we learn from meetings like this and from insight like this from Rosalind, it should be a responsibility to also educate the masses, because we are Kenyans, and I have been out there and people will say, Baba mesoma amesema, what I'm speaking about. John is laughing. They will say Baba amesoma na amesema, ama Uhuru amesoma amesema, ama Ruto amesoma amesema.
And they mean it. And they mean it.
Absolutely. Yeah. And it's true. And I did this even in the 2010 constitution. And I think we should take charge as individuals to just educate whoever we can, because a lot of people will probably not read what is being presented, even in the bills, even if they pass, even if they're merged, even if we go to a question or a multi answer question. let's take it as a responsibility to educate our neighbors, educate whoever that we can. And I'm so grateful to all of you who have participated. You're very educated lots, I must say. So let's take it upon ourselves to just spread the word, as Maureen said, spread the word. And Maureen, I hope we can have another opportunity to just share this platform. I see Sahara Rashid is saying, kindly share the notes. Maureen will do that. And let's continue to build Kenya, everybody. Thank you so much for joining us.
Thank you so much, Jackie, and we can now live at our own pleasure. Asanteni sana.
Okay, bye.
Goodbye. Bye,
Bye,
Tabu.
thank you.
Bye, Tabu.
Thank you, everybody. Thank you. It's lunchtime. Go have lunch.
Hashtag as we reject.
Thank you so much.
Mr.
Hi,
Tabu.
Jackie.
Hi. Mr. Tabu.
Yes.
Blood somewhere. Somebody has put what music. And this Morgan is that it.
I think now we've been given a break and a music to just break it up.
We have music break. Oh, okay. Thank you. God bless you all so much.
Sanfunga tena robo.